Oklahoma County opioid suit. Next, Mitchell Talks, the News 9 Sessions with Aaron Brevig. Here's my friend, Mr. Brillbeck, and Matt Sill with Fulmer Sill Law Firm. Good to have you, Matt.
Gentlemen, thank you for having me.
Help me out here. Lawsuit in Ohio, lawsuit in Cleveland. You've announced this week you're going to file in Oklahoma County a lawsuit. Help us understand what the difference is and what you're going to be doing in this county.
You're correct that Oklahoma County, along with 50 other cities and counties around Oklahoma, is going to be filing a lawsuit seeking to recover legal damages related to things like emergency health care and health insurance, criminal justice and victimization, substance abuse treatment and prevention, social costs, and lost productivity. They're seeking to recover from drug companies, including the manufacturers and the distributors that are responsible for the opioid epidemic. The case that you saw in Cleveland County was primarily against the manufacturers based on a public nuisance theory. And the cities and counties are also putting forth a public nuisance theory, but also have other causes of action and theories of liability against the drug companies.
Explain to me the basis for this public nuisance. What does that mean?
To abate a public nuisance is to fix the problem that's been created in your community. And so things that will be used in Oklahoma would be things like Narcan or naloxone that could save folks from an opioid overdose, or the day of action when drugs can be taken out of the community, or things like drug court and foster care services and things that have really been burdened by the opioid epidemic.
Oftentimes with a public nuisance trial, though, the remedy for it is to stop doing what you're doing, which the opioid companies say they've already done.
Well, the injunctive relief is important, but the effects of the devastating opioid crisis are going to be felt in Oklahoma for decades. And so there are a lot of things that need to be done other than just stop selling the pills on such a rampant basis.
If you're successful, where would the money go? And who would control it?
Well, in the case of Oklahoma County, that would go to the Oklahoma County Commissioners, and they would be advised on what is best to be done to abate the opioid crisis in Oklahoma County. The money would be earmarked for certain projects like I previously mentioned, like the Narcan and the substance abuse treatment and prevention.
I assume you'd have to go the same route as the state went in terms of spelling out exactly what those costs were, what those expenses were. Therefore, would that money be required to go towards abating those specific issues, or could it be used for other things? Or, in other words, am I going to see potholes filled with this money?
Potholes should not be filled with this money, and we don't want to overpromise and underdeliver that this is necessarily going to be a successful case, but the liability case against the drug companies is very strong, and so there are many things that can be done with the funds recovered.
I don't want to be over dramatic on this, but the fact was when the state settlement was done with Purdue Pharma, the legislature lost their mind. It was all behind the scenes, but man, they were really upset with the Attorney General. They're upset with the attorney fees, which are, big. They're upset with where the money was going. In this particular lawsuit, are you satisfied, because you're talking about being controlled by Commissioner Mon, Commissioner Calvi, Commissioner Blumert? Are you satisfied that where this would go would be a little tighter in terms of where the money would go as opposed to what happened at the state, which was so controversial?
Well, I think it's set out, and the public nuisance claims that have been delegated by the state to the communities give the authority to abate the public nuisance to the Board of County Commissioners. So I think there's no question where the recovery would go.
If this goes to trial, you've got a bit of an advantage because you've already seen the way that it was litigated by the state. You saw what the defense was from Johnson & Johnson and Jensen. And so you've got kind of a direction of which way they're going. Their argument is they followed all the federal laws, all the federal regulations in terms of the way they were promoting these drugs. And we also know that opioids are addictive. We've known this since the 15th century. How do we convince a jury or a judge, depending upon which direction the trial goes, how do we convince them that the doctors weren't responsible for this? The doctors didn't know any better?
Well, in the 90s, the drug companies were able to convince the doctors that opioids were not as addictive as they'd always been taught. They used short-term studies in controlled hospital settings for short-term treatment of pain and used those studies to promote opioids for long-term treatment of chronic pain when in fact the levels of addiction associated with that type of use were very high. And so doctors were misled. And with the drug companies' conduct, their warnings, in my opinion, are wholly inadequate, and the FDA and the general public and doctors were all completely misled.
Should doctors have known better, though? They go to medical school for this stuff. I mean, you talk with any 8th grader, they can tell you that opioids are addictive. How is it that doctors were this easily misled?
We're learning new things about the addictive nature of opioids every day. Sort of the correlation between the length of time opioids are taken and the levels of addiction. New information is emerging every day, but the drug companies had this information for decades.
The lawsuit, your lawsuit that you intend to file, deals with the distributors, is my understanding. Where in Cleveland County, they're mostly going after the manufacturers. The difference between the two is, are distributors in the Cleveland County lawsuit, are manufacturers in your lawsuit? Why the difference?
Well, in the Cleveland County trial, you only saw one group of defendants, the Johnson & Johnson group of defendants. That's one of the major manufacturers. In the county and city cases, you're dealing with both the manufacturers and the distributors. In fact, there are over 30 defendants in most of these cases. The distributors, some of the largest companies in the world, McKesson, I believe, is the 7th largest company in the world, AmerisourceBergen and Cardinal. They're the ones that had the ability to see the millions upon millions of pills that were coming into Oklahoma. In fact, there are more pills than people in Oklahoma, and they're the ones that had the ability to control that.
Where do we go from here? You've already announced that you're going to file the suit. Where do we stand as far as the paperwork? Kind of timeline this for me. When do we expect to start? Are you seeking a jury trial? Or are you seeking a bench trial?
We file every case with the understanding that we will be eventually before a jury. As you saw in Cleveland County, that was a bench trial, and that's something that we could always consider. But we're hoping to litigate these cases in Oklahoma State Court before Oklahoma jurors and the citizens that are affected by the opioid epidemic.
That's going to make it a bit tougher because, again, as we saw in the recent state case, the judge has been preparing for this for years. He knows about opioids. He understands opioids. With a jury trial, you're going to have to start with ground zero, educating a jury.
We like to tell the story, and we'd like to show everyone what these companies have done and the harm that they've caused.
The abatement issue, and then trying to do something about it in the future. We sit in a state right now where our public health outcomes are 49th. By the way, Mississippi, we love you very much. Thank you for being there for us.
Thanks, Mississippi.
Thank you, Mississippi. Shepard, thanks very much. We did this 20 years ago on smoking. We have $1 billion set aside to do something about smoking. By any measurement, it's a failure. 49th, every state that touches Oklahoma has worse smoking rates than Oklahoma. So while nobody has a problem with what's going on, the messaging over at TSET, for example, it ain't working. So when we're looking at these programs that are being set aside to fight addiction, how can we avoid the mistakes of the past, which clearly didn't work, for moving forward, taking those lessons of failure and moving forward? How can we be sure that this money is going to go towards something that succeeds?
Well, I think every community leader knows what's best for his or her community, and the abatement of the opioid crisis should take place at the community level. What's needed in a rural county might not be exactly the same as what's needed in Oklahoma County, where we have a big jail problem, so to speak. So at the community level, they have the chance to get it right.
When do you expect to file the paperwork? When do you expect a trial to start? How long do you expect the trial to last?
We filed many of these cases previously, but the Oklahoma County case we anticipate filing fairly soon. And that would be filed in Oklahoma County and Oklahoma State Court, and litigation would start proceeding immediately.
How long do we expect the trial would last?
A trial could last months.
That's a political answer and a legal answer right there.
All of the above.
Absolutely. Because it could. You don't know. I mean, that's one of those things we do not know. Well, hurling into the great unknown, it's going to be an interesting coverage, I'm sure, and we'll look forward to seeing what happens in your lawsuit, Matt.
We appreciate your interest and your focus on this.
Matt Seals, partner of Fulmer Seal Law Firm, and they're going to file that lawsuit on behalf of Oklahoma County residents coming up real soon. Thanks, Mr. Brobeck.
Thank you, sir.
Thanks for being here. See this again at news9.com/yourvotecounts. Follow me on Twitter, please, at Mitchell Talks.